Well, very much indeed for coming along this evening for the latest of our seminars in a series given by Old Square Chambers. This evening's topic is contractual remedies for breach of workplace procedures. And part of the focus of the discussion will be the recent Supreme Court case in Chabra and West London Mental Health Trust. You're going to be hearing from me initially, and then from Betsan Criddle, who appeared in that case, and Lance Harris, who's going to be talking about a recent case which reflects some of the issues that we're going to be discussing. At common law, a master is not bound to hear his servant before he dismisses him. He can act unreasonably or capriciously if he so chooses, but the dismissal is valid. A pronouncement you might have expected to come from some bewhiskered judge in the 1870s rather than the 1970s. What the House of Lords in Mallock was keen to stress is that that did not hold good for what they referred to as mere servants, or mere employees, whose contracts were terminable on notice, and who at that stage were seen as enjoying no form of procedural right. The employment relationship was essentially viewed as transactional in character. And the classic of case, of course, is the Johnson and Unisys case, where the implied term of mutual trust and confidence was relied upon by a claimant who'd suffered psychiatric illness as a result of the manner in which the dismissal process had been conducted. And he sought recovery on the basis that the recently adumbrated trust and confidence term had been breached. And by a majority, the House of Lords in that case rejected his claim, and they rejected it on the basis that Parliament had developed an alternative statutory remedy, and that it would create confusion and incoherence if common law remedies were developed in an inconsistent way in parallel with that statutory regime, a point expressed by Lord Millett in the Johnson case in rather apocalyptic terms. All coherence in our employment laws would be lost if the common law recognised a more extensive right to compensation for the manner of dismissal. It was a judgment that was heavily criticised in academic circles and has been to this day. The whole idea of the contract is a relationship that is devised by the parties. Why should it be assumed that their rights and remedies should be circumscribed by an intention imputed to them, that their remedies should be limited by virtue of there being a parallel statutory right? Lady Hale was one of those who was most uncomfortable with the decision when she considered it in a case called Gogay. She was then sitting in the Court of Appeal, and she found it odd that Gogay, the claimant in that case, should be able to recover damages for the way in which her suspension had been conducted. But if it had resulted in a dismissal, that would be precluded by what's referred to as the Johnson exclusion area. The reason I mention her view is that her lack of contentment with the Johnson decision and the Johnson approach has, I think, permeated some of the recent case law, including the Chabra case that we're going to come on to. But returning to Bristol City Council and Dedman, and what I think is a particularly significant part of the judgment, Lord Justice Morbick said that even if the policy is not apt to be treated as an express contractual provision, it may feed into the contract as part and parcel of the duty of trust and confidence. It may reflect the way in which the parties expect to be dealt with pursuant to that implied obligation. And therefore, it may be a relatively easy task for employees to establish that workplace procedures, unless they are wholly vague and sketchy in terms of their drafting, are intended, either express terms or by virtue of the trust and confidence term, to have contractual effect.
The development of implied terms has made the injunction jurisdiction considerably more interesting in the sense that there is potentially now a much greater scope to attack decisions in the High Court as opposed to having to wait until the dismissal has taken place and going to the employment tribunal. Because with express terms, say of a disciplinary procedure, it might say, for example, well, you're entitled to service of the case against you 3 weeks before the hearing, and you get it 2 weeks before. Are you going to go to the High Court and ask for an injunction to stop them going ahead with a disciplinary hearing because of short notice? Probably not, unless you can show that that in some way has really impacted on the ability to prosecute your case. But implied terms give much more potentially of a scope to intervene with the things, with more substantial matters, which drive at the heart of the process and its fairness. I'll now come on to talk about Chabra, and I'll talk a little about the facts of Chabra, because Chabra is a case that straddles a lot of these issues. It looks at categorization, it looks at grading, and it looks at another facet of fairness and broadens out the scope of implied terms even further from the implied term of trust and confidence, with the recognition of what the court described as an implied right to a fair procedure in the employment contract. Dr. Chabra remains a consultant psychiatrist working for the trust, and at the time of the events with which the court were concerned was working at Broadmoor Hospital, which needs no introduction. The allegations in the case were that she had read patient confidential material on a train, and she had dictated patient reports on the train, and that had been reported to the trust as matters of concern. An investigation was ensued into the concerns, and there was no finding of willful misconduct by the investigator. The investigator found that the allegations could be upheld, but noted the explanation that the doctor had given, and didn't go on to say, I consider that this was deliberate or willful on the part of the doctor. It becomes relevant later on. There were some other concerns about team working skills, which were accepted to be capability concerns about the doctor's medical practice. And the trust decided to convene a disciplinary hearing to consider the confidentiality concerns as disciplinary charges, and told Dr. Chabra that they were being considered as allegations of potential gross misconduct. And of course, as everybody knows, under the ACAS code, there is a requirement to tell the employee in advance how seriously you're potentially regarding the matter, and therefore what might be the consequences of the hearing. It went on to say that it was for the employee to decide on the most appropriate way forward. And for Dr. Chabra, it was argued that necessary meant that it had to be demanded by the circumstances, and that the trust fell short of that. And Lord Hodge said, no, necessary is what is appropriate in the circumstances. So gave rather more leeway to employers, pointing to the fact that it said it was for employers to decide on the most appropriate way forward. The disciplinary charges against Dr. Chabra were graded as potential gross misconduct. And it was argued for Dr. Chabra that the report didn't support that. The report, yes, said that the allegations could be upheld, but didn't find that there'd been willful or deliberate misconduct. And the Supreme Court agreed and said, and I've set out the quotation there, I do not think that the findings of fact and evidence which Dr. Taylor recorded were capable, when taken at their highest, of supporting a charge of gross misconduct. And then they refer to Dunn and Wilson and Raicher and say, to have gross misconduct, it must be conduct which could involve a repudiatory breach of contract. And the mere, I use the word advisedly, act or that the concerns in the case were not sufficient to support a charge of gross misconduct without some additional ingredient. Now, some people might think, well, breach of patient confidentiality is jolly serious, and therefore perhaps surprising that the court intervened. But that is the decision that they reached because they didn't feel that additional ingredient was there.
A good illustration of the court's approach to some of the issues that have been discussed this evening. That is the case of Ashworth and others in the Royal National Theatre, or as it's perhaps inevitably come to be known, the Warhorse case. The claimants were a number of professional musicians who were employed to provide live music during performances of Warhorse. The defendant was the National Theatre. The defendant's creative management team took the decision to move from live music during the performances to recorded music, and on that basis gave the claimants notice that their employment was going to be terminated on the grounds of redundancy. The claimants sought an interim injunction to prevent that dismissal taking effect. The matter came before Mr. Justice Cranston in the High Court, who applied the ordinary American cyanamide principles for applications such as these, whether there's a serious question to be tried, whether there is a real prospect of obtaining specific performance or a final injunction at trial, adequacy of damages, and the balance of convenience. Now, in respect of whether there is a specific, whether there was a serious question to be tried, the claimant's straightforward argument was the contract of employment provided for circumstances where either party could terminate the relationship. And in respect of the defendant, that could be done during a 26-week probationary period, or where the production was closed. But it did not provide, the contract did not provide the defendant the right to terminate employment on the basis of a creative decision to dispense with the orchestra. So the claimants, upon receiving their notice letters, affirmed their contracts and turned up for work. They were turned away, of course, and the defendant's position was that a proper construction of the contract, either the express terms or implied, that they did have a right to terminate in these circumstances. Mr. Justice Cranston held that there was a serious issue to be tried here. He accepted that the plain words of the contract did not cover what the National Theatre were purporting to do. And it's evident, although this was the interim stage, it's evident from the judgment that in fact the court felt that the claimants had a strong argument that this was a termination in breach of contract. Nevertheless, interim relief was refused. And it was refused on a number of grounds. Firstly, that the likelihood of obtaining a final injunction at trial were very limited. Perhaps a more persuasive ground for refusing the interim relief was on the basis, as the court found, that damages would be an adequate remedy. Now, this is, of course, at the interim stage. So what was being looked at is any loss that might be suffered between the interim application and the final hearing. And the court held that damages would be an adequate recompense if a final injunction was in fact granted. It's also illustrative of the general reluctance of the courts to intervene to keep an employment relationship alive where one party has indicated their intention to bring it to the end, even where there may be strong grounds for arguing that that termination is itself in breach of contract.
We are in the territory of discretionary remedies. Each case is inevitably going to turn on its own facts, and the disposition of the judge, of course, is an unquantifiable but significant ingredient in all of these cases. What the Warhorse case perhaps shows is a degree of conservatism in an approach at the interim stage towards a case where the judge was persuaded that a powerful merits argument was displayed, where at trial the judge might have concluded, at the full trial, the judge might have concluded that there was no proper contractual basis for discharging these employees and that their employment should continue. But those traditional barriers, and in particular the barrier of a lack of confidence in the employment relationship, still loom large and provide a basis for declining relief. And as Lance explained, the lack of confidence in that case was in a sense tenuous. The Chabra case is an interesting case in that it seems to introduce this broader standard of procedural fairness. And certainly there were features of that case which I think would have struck many people in this audience as deeply unsatisfactory and would have caused many of you to feel that something had gone awry with the process in that case. And you would have been inclined, perhaps, to look for a means of circumscribing the employer's freedom to proceed in quite the way that they proposed. The facts were somewhat extreme, and again, perhaps that introduces a caution about cases being specific to their own facts. But what is very important is to bear in mind the limiting ingredient that Betsan referred to about micromanagement. It was stressed in the Kulkarni case by Mr. Justice Betsan in the Makhdum case, and again it was underscored in Chabra that the court is very reticent about getting involved in the management of internal employment procedures, unless you can point to something which is effectively repudiatory in character, is sufficiently seismic for the court to say, this won't do, we have to restrain the manner in which this process is being conducted because it is likely seriously to impact upon and undermine fundamental employment rights.